populated. So hello, welcome to our February webinar on contractor disputes, what you need to know. My name is Elina Gilbert. I will be conducting this webinar today, and we're going to have so much fun. We really are. But before we start having fun, I'm sure you guys know I have to go through a few housekeeping things. So if you've done these webinars, as I always say, tune out, look at the Gilbert cartoon, it's funny. For those of you who have not done one of our webinars, listen closely. In front of you, on your computer screen, you should be seeing, the bulk of the screen should be the PowerPoint, the big Gilbert. You should see me at the bottom right-hand corner. Hello. And on the left, you're going to see a few tabs. And one of those is a little talking bubble icon, and I think there's a question mark icon. So I would like to ask that everyone use the question mark icon if possible with respect to typing in your questions, because I will go through those at the end, and it's just easier if they're all in one spot. But I will check obviously both places to make sure I don't miss any questions. But please, as we go through this, if you have questions, type them in. I will read them at the end and try to get to all of them. Next, for those of you who need credits, you will automatically get an email from us with a CMCA credit certificate for 1 hour. You should have it within 24 to 48 hours from this webinar. And if you don't, please reach out and let us know. And you can call Sean Sanders, who is our education coordinator, at 303-991-2076 if you have any questions. As we go through this, sometimes we have folks who have technical difficulties. So I am asking everyone to please, if you do have technical difficulties, don't type it in the screen, because there's really nothing I can do about it. A, I have no IT skills, and B, I'm teaching the webinar, so I can't really stop. However, that phone number I gave you, you can use that and call Sean, again, 303-991-2076. And Sean should be able to help you. All right, so without any further ado, should we go ahead and get started? Let's do it. Oh, one more thing. You might see me throughout this webinar kind of turning my head this way. And it's not because I don't want to look into the camera. It's because I've got two screens here in front of me. And for some reason, my PowerPoint is on this screen over here, and I can't move it over. So if I'm looking this way, it's only because I'm looking at my PowerPoint. So nothing against you guys. All right, let's do this. All right, so I suspect most of you, if not all of you, have at one point or another had issues with contractors, with boards who've had issues with contractors, and in one way or another been involved in a contract dispute. And so the purpose of this webinar is really to talk about, first of all, kind of what causes disputes, and certainly there's different things, but kind of ultimately, what is the crux here? Why do disputes happen, other than the obvious reasons? And what do we do when they happen? And what can we do to prevent them from happening? So that's really what we're going to talk about today. And so obviously the first part is, why do contracts go bad? What could possibly go wrong, right? All right, well, there's a lot of different reasons. I am going to talk to you about the ones that I think are kind of most pertinent, but by no means is this an all-inclusive list. So please don't think there's no other reasons out there, because we all know, there's a million reasons. So one of those reasons is there's no meeting of the minds. We're using different standards. Our assumptions aren't spelled out and the terms are not defined. So let's talk about those. If you actually look at this little cartoon right there, it's cute and funny, but it's also a great example of not defining terms and having different expectations. So this guy ordered a load of concrete. So in his mind, a load meant one thing, and to the contractor, a load was a truck full, and he's just doing this little pavement thing. That is a great example of a situation where we enter into a contract and we define something in one way, and contractor defines it in a different way. And there's no right or wrong here. It's just that if it's not spelled out in the contract, we're going to get this situation, right? And no one's technically wrong. But I suspect this homeowner isn't going to be happy with this truckload of concrete, and he's not going to want to pay for a truckload of concrete, and the contractor's not going to be happy because you ordered the load, so you have to pay for it. And that's really where it starts. So this is similar to no meeting of the minds and different standards. Essentially, no meeting of the minds, it's a legal term, it's a term of art really, and it just means we're not on the same page here. We are thinking of something different. And I'm thinking, like I'm defining this term one way, you're defining it a different way. I am defining that the standard, I am thinking that the standard of work is going to be this, but you're thinking it's going to be that. And that's what happens when we don't have something spelled out in a contract, is both parties are assuming, and someone's going to end up being unhappy because most of the time our assumptions are different. Okay, so spelling out assumptions, that is, again, super important. And you can't rely on what you think is either the logical definition of something or the logical assumption, or that something has to be in accordance with industry standards. Don't assume any of those things. We need to make sure all those items are set forth in writing in the contract. Let's keep talking. This cartoon is just funny, made me giggle. Handshake agreements that are not in writing. We're still talking about why contracts go bad. Contract not reviewed and blindly signed and did not read the fine print. So handshake agreements. I bet a lot of you have been involved in disputes where the board enters into some sort of a contract. Let's say it's a landscaping contract. And before signing the contract, the board president talks with the contractor and says, hey, can you also throw in, spraying for weeds once a month? And the contractor says, sure, I'll take care of it. But that never gets to the contract, right? It's never spelled out or written into the contract. The board signs the contract. And then they say, we're not getting our weeds sprayed. And we're supposed to get it sprayed once a month because the contractor told us it happened. Well, if it gets to an attorney, the attorney's going to say, where is it in the contract? Oh, it's not in the contract? Well, guess what? You're not going to be able to enforce it. Most contracts, if you look towards the end, you will see they have provisions that say something like, full and complete contract. And it'll say, this is a full and complete understanding of the parties. There are no outside agreements or understandings. And basically whatever's in writing in this contract is what it is, and there's nothing else. And ultimately, that's what gets people in trouble sometimes, is they do a little kind of on the side handshake agreement, and the contractor promises he's going to do X, Y, and Z, even though it may not be in the contract. Well, if you haven't added it in writing to the contract, there is no legal obligation for this contractor to do it. So keep that in mind. Handshake agreements are useless. If it's not in writing, it does not exist as far as we're concerned. Okay. Contract not reviewed and blindly signed. By whom? Yes, I do say legal should review contracts, but I'm also talking about the board or the manager, because sometimes if you read through a contract as much as you can, you will see that something in there is like, doesn't sound right, feels wrong, sounds wrong, and you're kind of like, what? I'm not sure about this provision. And I will tell you, as many times as I have had folks call me and say, what do you think of this provision in the contract? Their gut was right. Something was off. Either the provision didn't make sense, or it was one-sided, or it was something that we would never recommend an association agree to. But usually, when you do your own quick review, because you should know what you're signing or what your clients are signing, something's going to jump out at you. Now, that being said, generally, I do recommend that you have an attorney review a contract. I think you can set a dollar amount. So, for example, I would probably say $5,000 or more. Have the attorney review the contract and don't just sign it, because it's going to cost you more after the fact if something goes wrong and the association isn't protected than it would cost you for the attorney to actually just review the contract and negotiate it for you, so you do have adequate protections in there. And we'll talk about that in some more detail later on as well. So blindly signing a contract is bad, right? You did not read the fine print. So some people think it's a joke when I tell them this, but I kid you not. The attorneys in our office, I'd say 99% of them have magnifying glasses in their offices. Why? Because fine print. It's not just in contracts, it's in a lot of different documents, but there is always something that's very difficult to read, and you get your little magnifying glass and you're looking at it and you got to see what it says. There's a reason things are in small print a lot of times, and that reason is not a good reason, right? It's because they're trying to put something in there that people are going to ignore, but that benefits the contractor. So again, read the fine print, look through the contract, and yes, if it's over $5,000, especially if it's over $10,000, please have the association's attorney take a look at it. As an attorney representing HOAs, there has not once in my entire career, never have I had a situation where an association gave me a contract to review and I came back and said, oh, this is perfect. Never, never, ever. So am I being too subtle here when I say have it reviewed? If I am, let me know. I'll try to be clear. All right. We're going to have our comedic breaks in here. You know I like to do this, but most of them are Gilberts, and they are contract related. But this one, although funny, I think also proves a point. And this is, again, read the fine print, read the contract, even if you're not an attorney, and how are things defined. So this is one where, as you can see, sounds good, but then when you look at the defined term of pet, we would assume it would be Dogbert, but it's not, it's Gilbert. And we expect that from Dogbert. But it's just another example of don't make any assumptions when you're reading a contract, and don't assume that a word, especially one that talks about the quality, the quantity, the standards, that any word in there has a specific meaning if it's not defined. Okay. Okay. So I want to take a little bit of time and talk about this last provision. I keep mentioning it to you that, we want to make sure the association's adequately protected. We want to make sure that if something goes wrong, the association's covered. And a lot of times when you have communities that do blindly sign a contract, or that don't have their attorneys review the contract, and then something goes wrong, only then do they realize how much more money they are spending. So I just want to talk about some of these protections. This is not an all-inclusive list, but I picked, I think, some of the ones that are more important, perhaps, more significant, that can cause more harm if not, addressed. And I want to go through these with you just to make sure you guys at least have a checklist of things that you're looking for if you're not having an attorney review it. But again, I'm not suggesting that you not have attorneys review it. Okay, timing. So this is essentially, when does the contractor start the work and when does the contractor end the work? So, for example, are we going to start the work within a week after the contract is signed? Are we going to start it on a date specific, right? So when does it actually start? And from the date we start, how long is it going to take us to perform the work? Okay, so, and the reason we want this in here is because it is all too easy, again, for us to assume that, okay, so this project should take a couple months, and 10 months later, the contractor's still on site. Why is that? Well, could be a number of reasons. But the problem is, and I've had associations fall into this trap where the timing wasn't specified, and then they wanted to terminate the contract, or they wanted to send a demand letter to the contractor saying it's taken too long. And the contractor said, we don't have a timeline on here, and I'm going as fast as I can. And did that association really have much of a leg to stand on, saying there was a contract breach when no timeline was specified? Not really. And so you don't want to be in a position where you're saying, well, industry standards dictate that you should be done within this amount of time, because that's not a great argument. And that is a lot of work to have to prove that someone should have been done within a certain amount of time versus if it's in the contract. Now, of course, keep in mind, there are sometimes going to be delays that are beyond anyone's control. We saw it last year with COVID, right? There were times where everything slowed down. You couldn't be out there. The contractor couldn't have more than this many people working. And so there's always going to be some kind of a clause in a contract that basically makes an exception to the timing that says, hey, if there's acts of God or things beyond anyone's control, this can be extended, and that's fine, and that's typical. But in general, we want to have a timeline for how long the work is going to take. Scope of work. So that's really the description of the work. And that is usually, kind of the engineering specs, whatever the description of what the contractor is going to do. Usually that's what you see in your bids, the scope of work. And I'll be honest with you, and I bet you never would have guessed that I'm not an engineer and I'm not a painter. And so when I review contracts, I certainly could not tell you whether the scope of work itself is correct. But here's what I can tell you, and here's what you can do yourself, is you can see how detailed that description is. If all you have in your description is paint buildings in community, I would tell you that is by no means an adequate scope of work, right? Because first of all, we need to spell out which buildings. Do all buildings, does that include the clubhouse? Does that include the sheds? What is all buildings? What kind of paint is being used? What color is being used? Who's making that determination? I mean, we want as much detail as possible in the scope of work. So although we can't say, most of us can't say from a technical perspective whether it's being properly described, we can certainly say whether it looks adequate or whether we need to clarify anything. So don't just assume that the scope of work is, it's outside my knowledge base, I shouldn't even look at it. Definitely look at it, because things can jump out at you. And if it's really short and sweet with no detail, I think that should be a red flag. Attorney fees. So a lot of times when I say don't forget the attorney fees provision, somebody's going to snap back at me, well, sure, you want to get paid. And my smart ass response to them is, I'm getting paid either way. This isn't for my protection. This is for your protection, right? An attorney fees provision essentially says, if there is a legal action, then the prevailing party to that action is entitled to get an award from the court for its legal fees and costs. So that all the money we just spent paying an attorney, who's not cheap, by the way, right, to go after you go after the contractor based on a contract breach claim, we need to know that we can recoup those attorney's fees, because otherwise we're going to spend more money going after the contractor than we're going to get back. And obviously that's not always the case. If you've got a $2 million contract, you're not going to spend $2 million in attorney fees, I hope. But going through a full trial, if that's how far it goes, $50,000, $75,000, $100,000, more. Just depends on what the details are and how involved it is. Easy to spend that kind of money, and I certainly would never recommend an association spend money on an attorney if it's never going to be able to recoup those fees. And in Colorado, there is no automatic recovery to attorney's fees. If you win, it either has to be specifically set forth in the law or specifically set forth in an agreement. So there's nothing in Colorado law that says if you prevail on a contract claim, you get attorney's fees. So if it's not in the contract, you don't get it. So very important provision. Change orders. All right, change orders. Well, it is what it sounds like. If you're going to change from the scope of work that is described in your contract, especially if it's going to change how much the contractor is going to charge, it needs to be in writing, right? No assumptions. It needs to be in writing, and it needs to be signed by the contractor and by an association representative. It can't just be verbal. And what I usually like to add to contracts when I review them and I see, this change order language, if they even have it, is, and to the extent the contractor performs any additional work without a change order that's been signed, that contractor is not entitled to compensation for that additional work. And actually, contractors accept that language most of the time. They have no problem with it because they too are protected by the written change orders. Okay, works both ways. Venue. Venue is where we're going to file a lawsuit if we have one. If we have a legal action, where is it going to be? Why is this important? Well, because sometimes you're doing business with a company that's an out-of-state company. I've seen, contracts where it's a foreign corporation. It was incorporated in Massachusetts, and they try to pull one over on the association and says, if there is a dispute, it's going to be settled in a Massachusetts court. Well, of course, we're not going to do that. And if we don't change it to the county where the association is located, we may be stuck with that. And that pretty much defeats our ability to even do anything if you have to use a foreign court. So we always want to make sure that it's where the community is located and it's in the state of Colorado. Insurance. Insurance, what I'm referring to here is that the contractor is adequately insured. What does that mean? Well, we want to make sure, obviously, they have the workers' comp policy, right? We want, if one of their workers gets injured, we got to make sure that the contractor has, an adequate policy to cover them. Because if they don't, those workers can go after the association for coverage, which is also another reason why, off the topic, we always talk about associations carrying workers' comp. And I'm actually going to talk about that next month in the next webinar on insurance, so join us for that. But we want to make sure the contractor is adequately insured. So what else? They should have a liability policy as well. They should have a owned and non-owned auto liability, and that's basically if one of their employees hits someone with their car, and whether it's their personal car or it's a company truck or car, whatever, we want to make sure that they're going to be covered for any lawsuits that are coming from that. So if the contractor is not adequately insured, I would never recommend an association enter into any kind of a contract with that company or person or whoever. And so the other thing we want to make sure is that the association is named as an additional insured and that they provide us with a certificate of insurance. So A, we can see that they're adequately insured, and B, so we can see that we're named on there as an additional insured. So those are the types of things I typically will put into a contract if it's not there. Breach. What happens if someone breaches the contract? This is a two-way provision. You will typically see a provision in your contractor's original form contract that says if the association breaches the contract, all these horrible things are going to happen. And there's nothing in there about what happens if the contractor breaches, right? That's completely one-sided. And a contract breach provision will need to address situations where either party breaches the contract. An association can also breach the contract, right? We can not issue payment. We can, if we've agreed, for example, in the contract that they use our electricity and all of a sudden we cut off access to electricity, well, guess what? We've just breached the contract as well. So again, either party can breach. And what we need is a provision that talks about what happens in the event of breach. So normally you're going to see something about, you know, one party giving the other party notice and giving them a certain amount of time to come into compliance. And then basically if they don't do it, what happens? That's the key. What rights do we have if the contract is breached? Can we terminate? Can we withhold money? What can we do? So those are all things that need to get spelled out in this provision, because there's nothing in the statutes in Colorado that give us statutory remedies for this. So we want to make sure everything's in the contract. Early termination. What happens if we want to terminate the contract early? What if the contractor wants to terminate the contract early? I've seen some pretty creative things with these types of provisions, and not creative in a good way. Creative in the sense of they make no sense creative, and I know that if there's an early termination, we're just going to end up fighting about it. Creative in the sense that they basically say something like the whole contract amount comes due, which is completely crazy, especially if you've got another 2 years on the contract and they're claiming that they're entitled to that amount. No. And sometimes there's just a liquidated damages charge in there that is far, far, more than what it really should be. So again, those are provisions that need to be reviewed, and what happens if there's early termination. I like having those provisions in the contract, but they have to be properly set forth. And really what I ideally want them to say is, if we, the association, terminated early, we're going to pay you for the work you've done up until the termination point, but you're not getting paid for more than that. Use of subcontractors. Be careful with the subcontractors. I like to see a provision in a contract that says the contractor is going to use subcontractors if that's what's going to happen, because sometimes, and it depends on the contractor and the particular board, we want to add something in that says, we have to approve any subcontractor you use, because we may not want to deal with some of their subcontractors. And, you community managers, you've been around the block a lot, and you already have experience with various contractors. And I know there's contractors out there that you have not had good experiences with that you would probably never want to use again. So to the extent that a contractor can bring in one of those companies as a sub, you want to be able to have control over that. And if it's someone that we've had a really bad experience with, we want the ability to say, no, we don't want that subcontractor in there. Lien waivers. All right, I'm going to get in a soapbox for just a minute. I'm sorry, but lien waivers, what it really means is it's a document that comes from either the contractor or the subcontractor that says we have been paid and we release our right to record any kind of a mechanics lien for this portion of the work. What I've seen contractors doing in the last few years is they're telling the association they're giving them a lien waiver, but what the lien waiver says is I promise not to record a lien if I am paid. That's nothing. That doesn't give us anything that we don't already have at law. What the point of a lien waiver is for us to ensure that the contractor is paying his or her subs, and that they're not going to come back after us when the job is done and record liens on our property when we've already paid the contractor everything. I've seen this happen. I've seen situations where contractor used a sub, association paid contractor, it was like $150,000. I can't remember, what kind of a project it was. Contractor took the money, didn't pay its subs, and was off. And then the subs, under Colorado law, they can record mechanics liens against the property that benefited from their work. Or if they're a material supplier, they can record liens against the property that benefited from their supplies. And these associations, this association in this particular case, was left with these huge, huge mechanics liens that were recorded against their units. And the homeowners weren't very happy about that. And it took a bit of time to get it figured out. So don't be in that situation. You get a lien waiver, waiver from the contractor and from all the subcontractors. And we do this, like, especially if you have installment payments, they don't get their next payment until we have the lien waiver saying that the subs got paid for this portion of the work. Once we have it, all right, then the next portion of the work, we're going to need it again before we issue payment. So it's kind of like a domino effect. So don't get fooled by those lien waivers that say, oh yeah, we won't record a lien if you pay us. That's useless. We don't need that. Last but not least, notice there are going to be times when notice is going to be required either to the contractor, from the contractor, and to the association. So for example, like a notice of breach, notice of termination, whatever else. And we want to have a very clear and concise mechanism that describes where the notices go and how they have to be delivered. Sometimes contractors will put that in and it says something like certified mail, which is silly. I prefer snail mail, I prefer email, and so we want to make sure, regardless of what we end up putting in there, that there is a very clear mechanism specified, and that there is an address and an email address if it's getting emailed, and a fax number if it's getting faxed. All that information has to be in there. And if it's not, everybody's left to their own devices. So I called and I left a voicemail for the community manager, and that's notice enough. Meanwhile, here you are, community manager, you never got any kind of a voicemail. So are they just lying, or is there something wrong with the phone system? It doesn't matter, you didn't get the message. And they're saying they provided notice. If we have a provision that requires written notice and delivery of a certain kind, we're not going to have this issue. All right. All right, I'm done talking for this slide, but I will move on. Oh, good, comedic break. I like to make fun of attorneys, just so you know. There is a great quote. Here's Elina hypothesizing on life. There's a great quote out there. I believe it's Eleanor Roosevelt, but don't hold me to it. And she said something like, if you can't laugh at yourself, you may be missing the joke of the century. And I fully believe that, and I think it's really fun to laugh at attorneys. All right. Some red flags for you. I mean, we've already talked about all this stuff, right? But just a few red flags that should automatically get your attention. If you have a 1 or 2 page contract, and we're talking about thousands of dollars of work. Last week, I got an email from one of my boards. It was a self-managed community, and they forwarded me a 3-page contract. 2 pages of it was the work description, and 1 page was the terms and conditions. The contract itself, if you add all the work up, was somewhere around $800,000. And they said, hey, can you review this? And I said, how about I write it, because you do not have a contract here. This is not at all adequate. for an $800,000 project. And I had to actually write them a contract. Now, I took their scope of work and incorporated it into the contract, but I wrote the contract and all the terms and conditions and the terms of payment, because a 3-pager is not going to be enough. There's just not enough room on 3 pages to put in everything that you need to put in. So be careful with those 1 or 2 page contracts. Blanks in the document. Sure, there's always going to be blanks like for a date in the signature line. That's not what I'm talking about. What I'm talking about is there are contracts that'll leave blanks as far as, and the late fee is going to be X, and we give you this much time, to let us know if there's a problem with the work. Though, there's blanks in various contract forms that I see are still there when the association is like ready to sign this, and they're telling me, hey, take one final look. I look at it and I say, well, what about the blanks? Well, we're going to fill those in later. No, you don't fill those in later, because that's when you have a contract and somebody's making assumptions and you're not going to be on the same page, and you're not going to have anything in the contract at that point to help figure out kind of what the specifics are. Never sign a contract that still has blanks in it. Again, I don't care about the date, because we'll date it when we sign it. I care about anything other than that. Blanks for even where we send notice. Don't ever leave blanks when you sign a contract. Whew. All right, last one. And again, these are not the only red flags, but these are the ones that I think are like the easiest to spot. A contract that does not name the association as the contracting party. Well, who would they name? Well, I've seen contracts name individual board members. That's a big no. I've seen contract name individual managers. That's a big no. And I've seen contractors put the management companies in there as the contracting parties. Another big no, right? So be careful, especially when community managers, if you guys are authorized to sign on behalf of your boards, and you do that, be very careful. You really want to make sure that the association is the named party, not an individual person, because the association is a corporation. And we don't need there to be any liability exposure for any individuals beyond the corporate liability, okay? So be very careful with that. And also, I always say, make sure it's the full legal name of the association, because if it's not, there's quite a few companies out there that have very similar names, and the difference could be one word, one comma, one, Inc. Incorporated. And if it's not the full legal name of the association, it could be a contract with a completely different company, and that could be a problem. So just be careful with those. All right, we're to the kind of the third part here, and that is, what steps do we take when a dispute does arise? We've looked at the contract, we've had an attorney look at the contract, we've negotiated, we've signed it. Well, now we've got a dispute. What do we do? All right. Are you ready for this? Here's the magic answer. No, there's no magic answer. The only magic answer is, I suppose, you could turn it over to legal counsel. But here's a few steps that should be taken. So let's assume you have a landscaping contract, and your board says the contractor was supposed to show up and prune the trees in June. It is now July. They didn't do it, and therefore they breached the contract. That's the complaint, and you're the community manager. You would want to ask your board, I think, well, how do you know they didn't come out in June? What evidence, what proof do you have? What documentation do you have? And let's say you get a response of, well, we didn't see them. Nobody in the community saw them. And the trees didn't change at all. They didn't look like anyone trimmed or pruned them. Okay, so watch out for words like everybody, nobody. So if you got a board saying nobody saw them, my response would be, have you talked to every single homeowner and resident in the community to make sure they didn't see them? Because that's a pretty broad statement, and it sounds like somebody is making assumptions, because I highly doubt you've talked to every single resident in the community. However, if, and the trees didn't change, well, do we have pictures of the trees throughout the month and every day of the month so we can compare them? Probably not. So what we're dealing with in this case is some assumptions, I think. And maybe they're good assumptions, maybe they're not, but that's what you're going to be dealing with. So the next step is, do you have the contractor side of the story? Has anyone actually reached out to the contractor to say, hey, we don't think the trees have been pruned or trimmed? Sometimes I see boards jumping to these conclusions, and they immediately go to the place of, we're not paying them until they do this, but nobody's even talked to the contractor yet. So my first recommendation when I speak with a board member or a community manager that's having an issue with a contractor is, have you talked to the contractor? Because if you haven't, you should talk to them, because you may get this resolved very quickly, easily, and cheaply, and not have to pay an attorney if you just talk to the contractor. I've seen situations where the manager or the board would reach out to the contractor and be like, hey, we don't think this was done. And the contractor would be like, oh my God, I'm so sorry. Let me take care of this for you. I've seen situations where it doesn't go that way and the contractor says, yes, it was done and now you're going to pay me for it. So it could go either way, but you certainly need to try to get with a contractor to figure out whether it's something that can be fixed easily or not. So that's kind of the first step, is just figuring out, are these facts, are these opinions, where are the assumptions? Do we have any real proof that these alleged facts or non-facts have occurred? All right, so let's say in our current scenario, you've talked to the board, they're insisting that, they didn't come out in June, they didn't prune the trees, people didn't see them, nothing changed, the trees look exactly the same. You have then reached out to the contractor, and the contractor said, screw you, we pruned the trees, and we're going to charge you for it. All right, so let's go to step 2. What does the contract say? So the first thing is, let's assume that the allegations in this case are true. They did not prune the trees in June. Does the contract require them to prune the trees in June? Sometimes boards are, they're convinced that there's something in that contract that requires someone to do something, but nobody's looked at the contract. And so the first thing I would do is, all right, well, is there a provision in the contract that says contractor's going to come out in June and prune the trees? If there isn't, I don't think there's been a breach. Now, there might be an issue if you get a bill from the contractor that says, I pruned the trees and you need to pay me for this. But if the contractor isn't billing you for it and the board is simply upset because the trees weren't pruned in June, and there is no obligation to prune the trees in June, then there's no breach. Now, there may be an obligation to prune the trees in the summer months, but that doesn't mean June, right? So we got to be very careful about what is the actual requirement and the obligations of the contractor. So you've reviewed the contract, and the contract says, yes, the trees shall be pruned in June. So if we assume that the board's allegations are correct, there has been a breach. The next question becomes, what do we do now, right? What are the remedies? Well, that's where, again, you cannot assume that we just can stop payment or that we can just terminate the contract. You've got to look at the provisions, and that was that provision of breach, right? We just talked about it. The provision that spells out what happens in the event of breach. You need to look at that provision, and you need to follow that provision before you do anything else. All right, now you've done all this. So Even if you think you know the answer, even if you've gone through all these steps, you've read the contract, please don't withhold payment before talking with the association's counsel. Please do not try to terminate the contract before consulting with the association's attorney. And please, please, please do not take any adverse action before consulting with the attorney. I appreciate boards kind of doing their own legwork and then coming to me saying, okay, here's what our contract says and here's what we did. And I say, okay. So then I look through the contract and I look through all the facts, and it turns out there's no breach, or it turns out that you didn't send your notice correctly because it requires to be, it has to be sent by certified and you sent it by regular mail. I cannot tell you how many times I have worked with boards and managers where they thought they had it figured out and they were really proud, and I'm glad, but they were wrong. And fixing the mistake is going to cost more money than just doing it right the first time. And so you may be absolutely correct that what you need to do is send a letter saying you didn't prune the trees. We're giving you 30 days to prune the trees and provide us with proof that you've pruned the trees. That may be the absolute right way to go, but there may be some small little detail in there that's also required that you missed. Are you, as a board member or community manager, willing to take on that risk? It's not worth it, right? Let the risk fall with the attorneys. Because if we then advise you to do this and we're wrong, it's on us, it's not on you. Not that we would advise you incorrectly. But again, I don't know if I made it clear enough that you should consult with an attorney before doing anything, and I'm kidding, I know I made it clear. All right. Boys, this one's for you, the picture. Sorry. Hopefully you appreciate it. Or don't appreciate it. So typical disputes, and this is really just for you to say, yeah, this is right. This is what I've been involved with. You got a contractor that damages association property, or a contractor where we say, hey, that they didn't do the work right. They re-roofed, but now our roofs are leaking. So that, they didn't do it right. It's taking too long to finish the work. I'm trying to call the contractor, but they're not answering me. They're not responding to any of my communication attempts. We've all been there. We've all seen that, right? But all of these, every single one of these examples is going to fall into that 3-step process that we just talked about. No one is immune. We might think that, our roof leaked and you just re-roofed, therefore, automatically we are entitled to withhold final payment. But that may not be what the contract says. Right? The work is taking too long. We talked about this early on. If the work is taking too long, is there anything in the contract that tells us how long the work is supposed to take? Contractor unresponsive. I see this one all the time. And usually this isn't the reason for boards terminating a contract, but it's typically like the straw that breaks the camel's back, where we're having problems and we're trying to work with the contractor, but they're ignoring us, or at least it appears to us that they're ignoring us, right? I think that combined with something else is usually when we see the homeowners or the board say, screw that, we're canceling this contract, we're not paying this contractor. So I get it, but that doesn't mean we shouldn't go through the analysis that we just talked about. So this is Calvin and Hobbes. I'm kind of dating myself. I hope you guys are all familiar with Calvin and Hobbes. And this is the old this one is a prenatal contract, I believe. I don't know how you review that one. All right. So I am done with my bantering. I am now going to go through all your questions. Let me just start at the bottom here. All right. Should a contractor be allowed back onto the property to complete contracted work even if the contract has expired? This work included in the HOA landscape maintenance contract that was not completed before the term of the contract had expired. Well, I would urge you to go through the same three-step process. And so if the contract's terminated, what does it say? What does it say? I mean, it sounds to me like perhaps that's a breach, but is it? Does it speak to what happens if the contractor doesn't finish the work? Does it guarantee the contractor will finish the work? Is the contractor trying to charge you for this work? So I think a lot of this is going to be very fact specific, and I would really encourage you to look at the contract itself first. And if there's nothing in there at all about that, I would wonder if the contractor is not charging you for that additional work. Does the association prefer someone else do it? Is it worth the fight? Is it worth the headache to argue about, well, you were supposed to do it, but you didn't? If you paid for it, then you fight over it. But hopefully you didn't pay for it. If a contract does not specify something was missed by both manager and contractor, but later agreed upon by email correspondence after the start of the project, do you need to revise or rewrite the contract? I don't think so. I think to me that sounds more like a change order. So if you have an email exchange and it sets out like, here's the additional work, here's how the additional compensation, the one thing I would want is for that to be signed by a representative of the contractor and a representative of the association. Okay. Now, again, it's in here, it says, I'm not going to try to read into it, but it says both manager and contractor. I am assuming that the board is also aware of whatever this missing thing is and is in agreement that it be added to the contract. That's all. Because I think ultimately the board needs to make these decisions unless they've delegated all of that to the community manager. What language do you recommend for attorney's fees? Is there standard language? I like to use the language that basically says in the event of a legal action arising out of or in any way related to this contract, the prevailing party entitled to its legal fees and costs, something along those lines. I'd legalese it up just a little bit, but something along those lines. I've seen it just say, if there's a lawsuit, the winning party gets legal fees and costs. We'd want it to be a little prettier than that, but I think that gets the message across as well. Additional insurance certificate names both association and management company. It should only name the association. I don't typically see it naming the management company. And the reason is because the management company is usually entitled to indemnification from the association if it is named in a party or in a lawsuit that arises out of something, the management company did in the line of duty. So it's the association that would then indemnify the management company. And so there's no need to have the management company on that certificate. Now, if you have it added and the contractor's added the management company, I'm not gonna, be against that, but I'm just saying it's not typically done. Should we post signs on the property that is having work performed on it? And I forget the exact verbiage, but it states that a lien cannot be placed on the property by anyone conducting work on the property. Well, I mean, you can place a sign like that, but the law says what it says, and they still can they can still record a lien on it. The law gives them that authority whether or not we have the sign. So honestly, I don't think a sign's going to do us any good. So I wouldn't waste money on getting signs that say that. What do you recommend as the association address for billing address or site address? I usually would say whoever you want communications sent to. Normally I see the managing agent, the management company and the individual manager on there. If it's a self-managed community, sometimes I'll see they'll put like the name of the board president. Sometimes they want it to be us, which is fine, but then just know if there's ever a notice going that you're going to be charged for us to have to review it and then advise you on it. But usually 99% of the times it's the community manager. How should contracts be signed? As the community name, your name as manager, have the board sign. Well, I know there's a lot of management companies out there that have a policy internally that says we do not sign contracts on behalf of our associations. So, you know, if obviously you work for a management company that has that policy, you're not ever going to be signing the contracts. But I would always recommend that it be signed, like if it's a board member, it's signed kind of like, you know, John Doe as president of the association. If you're signing it as a community manager, you sign it, you know, Jane Doe as managing agent of association, something like that. You're always signing it as an agent of some sort. So it's clear it's not, you're not, you know, the person who's responsible for the contract, but you're an agent. Okay. Go back to owned, non-owned policy. How can the HOA be held liable for injury, death, property damage if a painting company's vehicle is involved in the accident when he is on the job to or leaving from the job? I'll tell you how, because contractors are our agents. When you sign a contract as an association with a contractor, you become the principal, they become the agent. In Colorado, principals are responsible for the actions of their agents. So if you've got an agent that does something stupid and negligent and there's damage, you're going to be on the hook for it. Now, you can also go back and try to recover from your contractor. I'm not saying they have no liability, but what I'm saying is you're going to share in that liability as the principal. And this is no different like when if you have a roofer go on your roof and they redo the roof and they screw up and the unit gets flooded, our documents might say that the homeowner is responsible for the interior of their unit. But if it's caused by the negligence of our contractor, our agent, that's going to shift the burden to the association then to go in and repair it, to pay for the repairs to that unit, because it's our contractor's fault. Thank you for your presentation. You're very welcome. The paving work was completed in September, but not to the board's satisfaction. The contractor has been back twice. Board is still not satisfied. Payment has been withheld until board is satisfied. Multiple pleas to contractor to meet with the board, but to no avail. Where do we go from here? Well, I think if the board is not paying the contractor, at some point, you're probably going to see a mechanics lien recorded against the property where the work was done. It's a paving contractor, so I suspect they're going to say we can record a lien against all the individual homes, units in the community because they're benefited by this work. And if that happens, then the next legal step for the contractor would be they could foreclose on their lien and actually try to foreclose against the units in whatever amount. So it's not a pretty thing. The other option is the contractor could file a lawsuit against the association. And if that's the case, check with your insurance agents, because most of the time, contract breach claims are not covered by insurance, which means the association is paying out of pocket to defend itself in court. Okay. What is a performance bond and when are they necessary? I personally don't use performance bonds in my contracts. It's not much different than like being able to withhold money. A performance bond is something filed by the contractor. Usually it's filed with a separate bond company or sometimes with a city, and it's money that they put in there that doesn't get released until not the contractor, but the contracting party, so like the association, is basically done with the work and they say it's good and they accept it. So it's not much different than having a provision that says we can withhold the last 10% of the contract price until full and final satisfaction, something like that. So I don't usually use performance bonds. Manager hires a contractor for specific work to be done. Not sure where the question is, but managers should not be hiring. It should be the association that's hiring. And thanks, Elina. You're very welcome. And we are right at 1 o'clock. And you guys, thank you. Oh, let me do the final slide not coming up. Oh, fine. Thank you all for coming. Enjoy the dancing chicken and pig. Until next time, if you have questions, feel free to shoot me an email and I'll do my best to respond as soon as I can. Thanks, everyone.